Thank you everyone for joining us. Very excited to have Alastair McClure here today to speak about his new book. And Alastair joins us from the University of Hong Kong, Department of History. And his first book is with the Cambridge series and studies on legal history. He's done a lot of work on legal history. He's on the editorial board of Law and History Review and written a bunch of very interesting erudite pieces on legal history, including capital punishment and sovereign violence and the making of criminal law in India. And so I'm excited to hear more about his work. So Alistair would present for about 45 minutes and I'd give brief comments and then we can open up for a discussion. Thank you.
Okay. Thank you all for coming, and special thanks to Sabarish and Ivan for all their help organizing this talk. It's really exciting as a legal historian to be in NUS at a place that's doing such interesting work at the intersection of law and humanities. So thank you for having me. Okay, so let me begin. Because I pre-circulated a chapter, I thought rather than spend most of my time talking about the content of that chapter, it would be more useful if I instead provided a little bit of context from where this chapter comes, drawing on other parts of the book, which you haven't read, and to situate Tilak and his interventions, and then also to speak a little bit about where the book came from, what are its historiographical and conceptual debates that it speaks to, and how I seek to contribute to this literature, hopefully in interesting ways. So I'm going to talk a bit about what became before Tilak's trials and what happened after. And if all goes well, that should give you some sense about why his trials were important, but also the basic parameters of the book project. Okay, so where did the book develop from? So the research began in about 10 years ago now, at a time in which scholars of South Asia and the British Empire were making a very forceful argument that historians in particular had long underexamined and underappreciated the central role and importance that physical violence played in empire. Now, in the context of South Asia, which is mainly my field, this literature took, I think, one of two approaches. One set of scholars looked to the everydayness of colonial violence. They pointed to the sheer scale of quotidian acts of brutality, often acts of violence that were afforded almost complete impunity in the courts, and argued that violence shouldn't be understood as an aberration, but rather a structural feature of colonial rule. And here we could point to the writings of people like Jordana Belkin, Dina Heath, and Elizabeth Kolsky, amongst others. A second set of scholars approached the question of violence from a different entry point. They focused on the extensive use of martial law, the proliferation of emergency powers, which legalized extreme violence in the colony. Now, these scholars showed or suggested that what on paper was often described as temporary powers reserved for exceptional circumstances were in practice common and many instances permanent features of colonial legality. So we have the classic writings of Nasser Hussain, alongside newer scholarship by people like Kim Wagner, Mark Kondos, Deborah Ghosh, and Joseph McQuaid. Now, when I began the writing for this book, I intended to write a legal history of colonial violence that sought to bridge what I felt was an unnecessary and perhaps even unhelpful entry point into this question. I wanted to explore the historical relationship between sovereignty, criminal law, and colonial violence by placing the everyday and the exception within one analytical framework. However, as I spent more time with my sources, other questions became more interesting, and it was at this point, quite slowly, I started to think that mercy might be the most important aspect of this story. So looking back, there were sort of two moments that I can point to that were important for this project's development. So on the screen here, you can see a very haunting photograph of Bahadur Shah Zafar II, the last Mughal emperor. Bahadur Shah was arrested by the British in 1857 amidst the largest anti-colonial uprising in the British Empire in the 19th century, for which he was the largely symbolic leader. In response to the uprising, the colonial state deployed extreme violence and retributive terror. Thousands of rebels were tortured and sentenced to death in summary decisions. Many rebels were hanged in public. Others were shot from cannons in excruciating spectacles. Now, as this movement begins to collapse, Bahadur Shah would surrender to the British on the promise that his life would be spared. Now, this negotiated surrender elicits much discussion amongst colonial officials, many of whom expressly call for his head, as you can see on the screen here. However, after some discussion, it is agreed that the promise would have to hold. Bahadur Shah would not be killed. Instead, a show trial is organized for him in the Red Fort, which is the image on the screen, where he is charged with treason and murder. He is found guilty and transported to Rangoon, where he would stay until his dying days. Now, if Bahadur Shah was placed on trial during one of the most infamous periods of colonial violence and emergency, as I mentioned, I also wanted to explore the politics of state violence in more everyday circumstances. Now, for me, this meant digging through case law published in the Indian law reports on murder, which was the most commonly capitally punished offence in India during this period. Now, in these records, several reoccurring themes appear again and again. So, in particular, violent and jealous husbands who killed their wives, and disputes between neighbours about property that ended in murderous violence. Now, as I read through the case law, what quickly struck me was the disproportionate amount of published judgments in which the accused had been found guilty of murder, but the judge had decided not to sentence the accused to death. Instead, they were punished with the more lenient sentence of transportation for life. Now, if these types of trials were relatively common in the law reports, I will stress here that they should not be considered evidence of a scaffold-shy colonial judiciary. This was a period of time in which the number of death sentences and executions each year was rising, a pattern that would continue right until independence. Now, this, of course, is in complete contrast to the rapidly diminishing number of death sentences and executions in the metropole and in settler colonies during this period. And so what I had in the trial of the most important rebel leader in the 19th century during a large anti-colonial uprising and in long-forgotten murder trials was evidence that judges and officials in certain circumstances and for certain reasons recognized that colonial authority was served best not in the decision to kill, but in the decision to let live. So this encouraged me to return to the archives with the intention of looking both for acts of violence, but also moments of mercy, discretion, and leniency. Now, as I did that, I found material surprisingly easy to come by. I found amnesties organized in almost every decade between 1850 to 1920. I found the organization of impromptu mercy programs for specific crimes like infanticide. I saw intense constitutional debates and in many cases outright confusion about the prerogative powers of pardon in the context of colonial India. And I found careful discussion about the conditions upon which some anti-colonial leaders might be had their sentences commuted and released early. Of equal importance, I also found careful thinking about imperial mercy in the speeches and writings of some of the most important Indian nationalists of this period, none of which had been seriously studied. And this became the puzzle the book tries to put together. What work were acts of mercy doing in an otherwise violent and bloody penal order? Now, in putting this puzzle together, the book makes two larger arguments. First, it's important to stress here that to take seriously the role of mercy in empire is by no means to argue that colonial rule was any less violent or more infused with humanitarian sentiment than existing scholarship has demonstrated. Instead, the book makes a case that by studying empire's mercy, in fact, we understand its terror better. It allows us to track the unevenness of colonial violence and to follow the processes by which different Indian subjects, whether due to caste, class, or gender, or some combination of these categories, were made more or less vulnerable to the state's punitive instincts. Here I argue that mercy and terror were related expressions of sovereign power. In most cases, the decision to punish with harshness was born of the same logic that resulted in others being recognized as deserving of leniency. Once we recognize this, it becomes quickly apparent that the wide discretionary powers to decide punishment woven into the penal order in India were wielded as the key technologies of colonial rule that enabled judges and officials to manage a highly stratified social and political order, ruling through a legal code that terrified the majority while ensuring conditional leniency was available to a small minority, encouraging them to continue to approach colonial institutions, submit appeals, file petitions, and ask for justice, and in the process, confer the colonial state and its political project with some degree of legitimacy. Now, my second argument relates to intellectual history. Hitherto, scholarly work on colonial violence has focused largely on the colonial state. My book, by contrast, suggests that rather than treating the history of state violence and anti-colonial political thought as separate fields of inquiry, the history of colonial punishment affords us an opportunity to productively bring this scholarship together. By doing so, and more specifically, I hope to demonstrate that contestations around imperial mercy was a key arena of struggle in broader histories of anti-colonial liberation. Now, because of the content of the pre-circulated chapter, and in the interest of time, I'm going to focus primarily on the second aspect of these arguments, to track why and how anti-colonial thinking in relation to mercy would become such an important feature of nationalist politics and organizing in the early 20th century. Now, to understand why mercy would become so important, we need to begin our story by traveling back just over half a century and examining the work of mercy at the moment India becomes a crown colony in 1858, in the immediate aftermath of that uprising I mentioned. Here we need to turn to the Queen's proclamation. Now, this proclamation was read in towns and cities across India on November 1st to publicly announce the return of the colonial peace. It also declared a new political settlement, one in which imperial sovereignty would be grounded in the British Crown and the Crown alone. This swept away the awkward political arrangement that preceded it, one in which sovereignty had been shared across the Crown, the East India Company, and the last Mughal emperor. Now, as historians have long argued, this proclamation represented a powerful symbolic document that captures an ideological shift in imperial thinking, one often described as indirect rule. The proclamation explains that in return for subjects' loyalty and allegiance, Indians would be promised economic and technological progress, equality under the law, and crucially, a guarantee that the state would not interfere in local customs and religious affairs. Now, a comparatively overlooked, but I would argue equally consequential aspect of this document at the time, however, related to mercy. In its penultimate paragraphs, the proclamation offers an amnesty to all rebels, to almost all rebels, in return for their surrender. Now I'm going to read this the section in full. I apologize, it's a bit lengthy because it's very important. So these sections say, we deeply lament the evils and misery which have been brought upon India by the acts of ambitious men who have deceived their countrymen by false reports and led them into open rebellion. Our power has been shown by the suppression of that rebellion in the field. We desire to show our mercy by pardoning the offences of those who have thus been misled, but who desire to return to the path of duty. Our clemency will be extended to all offenders, save and except those who have been or shall be convicted of having directly taken part in the murder of British subjects. With regard to such, the demands of justice forbid the exercise of mercy. To all others in arms against the government, we hereby promise unconditional pardon, amnesty, and oblivion of all offences against ourselves, our crown and dignity, on the return to their homes and peaceful pursuits. Now, for any rebels intending to accept this offer of mercy, they would have to fill in the form you see on the screen, which would be then recorded in police stations. The form asked the individual to provide information about their identity, their father's name, their address, their religious and caste background, and any notable information about their physical appearance. It also meant agreeing to the terms of amnesty, which you can see just about on the bottom of the document. Now, there are two arguments I want to make about the political work being asked of amnesty at this moment. First, amnesty sought to introduce a new official history of this period of founding violence. And here it's important to remember that amnesties were never just about the politics of forgiving. They were also about the politics of forgetting. So what was being forgotten here? Well, as many of you will know, the violence of 1857 had been organized by rallying around the last Mughal emperor. And it's important to know that while his authority was severely diminished, he had never formally ceded sovereignty. The violence was also an articulation of a popular right recognized by Indians from across religious backgrounds to wage war against what they considered to be an illegitimate form of political authority, the company. Now, the proclamation explains mercy is unconditional, but forgiveness here was being hinged upon rebels' willingness to accept a very different narrative, namely that they had been tricked and misled into rebellion by ambitious men, ambitious men enacted a criminal act of revolt, definitively not a war. Mercy therefore emptied this conflict of its popular politics and the deep grievances that had led so many to pick up arms, ring-fencing agency and culpability in a small group of agitators. It was a bargain, one which demanded the rebel not only lay down their arms, but also relinquish any claims to political consciousness associated with their decision to turn to violence. Now, the second thing I want to note here is the relational work of mercy and terror. Mercy helped create a boundary dividing those that could be forgiven and thus allowed to re-enter the colonial order from those deemed beyond the pale, who demand punishment and in many cases death. Now, this was a pragmatic move by a colonial state, which recognized it couldn't possibly hunt down every rebel, but it also was a means of bolstering the legitimacy of colonialism in India by framing itself as merciful rather than revengeful. So it's on this proclamation, later popularly known as India's Magna Carta, that crown sovereignty is then hoisted and upon which this new political order is crafted. Now, it's really important to sort of underscore the scale of this operation. The Programme of Mercy required investing huge discretionary authority in local commissioners located across northern India. Working on the ground, these commissioners were tasked with determining who deserved mercy and to what extent, and who deserved punishment. Alongside this Programme of Mercy was also a programme of reward for the loyal, and the reward programme you can see on the screen here, which lists the individuals and how they were rewarded, their position, what they did, and how they were how they were rewarded. Now, similar tables were also found for mercy and punishment, and those tables are the same as these. They just exchange notes of service for the loyal to acts of disloyalty for the rebel, and how rewarded with how furnished, which was recorded how they were punished. Now, taken as a collective, the decision to forgive, punish, or reward resulted therefore in large portions of Indian society being marked by their behaviour during this founding period of political reordering. As an exercise of intensifying state authority deep into the Indian social, it functioned to massively reallocate resources, privileges, rights, and status through the redistribution of thousands of confiscated villages, acres of land, government positions, pensions, and even things like the right to possess arms, which were all handed to the loyal. Those in principle forgiven for their crimes were allowed to re-enter this newly ordered political world, but often did so after being stripped of their property and marked as suspect through their history of rebellion. Now, in the chapters that connect the amnesty in 1858 to the Tilak trial that you read, I then follow how criminal law was codified through the Indian Penal Code and the Code of Criminal Procedure, the construction of new high courts, and then the politics of punishment thereafter. In particular, I pay specific attention to the considerable role of discretion, which has remained in the codified penal order. And especially interesting here is that judges and executive authorities, particularly in serious crimes like capital crimes and sedition, were invested with a lot of discretionary authority, often discretionary authority that exceeded that available to their counterparts in the metropole, when it came to deciding when, who, and how to punish. Now, in the interest of time, I won't go into detail about what these chapters show, but what is relevant to the chapter that you have read is that what immediately precedes the emergence of the state trial as one of the key spectacles of anti-colonial nationalist politics is an organized retreat by the colonial state from public executions for particular types of crimes. So in the chapter that precedes what you've read, I examine a very fraught discussion and debate around how to punish revolutionary nationalists who were tried, sentenced, and hanged for politically inspired acts of murder and violence. Now, these figures provoke real anxiety among colonial officials who express real reluctance in publicly executing popular figures who explain their actions in the name of the nation. As a result, the colonial state institutes clear rules and policies that ensure political criminals would be killed in private and in secret. And this is really important because what we see is as the public scaffold is retreating in colonial India, in essence, a tacit acknowledgement that the state's right to punish had been compromised by the anti-colonial nation, what replaces that spectacle is the public spectacle of the political trial. Now, for the remainder of my talk, I want to focus on those state trials, and much of this will be what you've read in the chapter, so I apologize for those of you for repeating myself a little bit. But I want to sort of talk a little bit about how that 1858 settlement starts to break down through these state trials. Now, I want to note a couple of things here about sedition as an offence. Firstly, sedition was introduced in India in 1870. And Indian voices at the time were highly critical of a law which they rightly believed to have serious implications for press freedoms. Colonial officials also expressed anxiety about this section, but did so for a very different reason. So they argued that the definition of 124A, sedition in the IPC, was ambiguously constructed and risk-making prosecution difficult. And they're particularly worried about this section in yellow here, excite feelings of disaffection, which they thought was the real issue. Now, it would be very easy to dismiss these fears as another example of colonial officials seeking ever more repressive laws, but as we will see, these concerns were not completely misplaced. The second thing I want to note is that the offence granted judges wide discretion in punishment, which could range from transportation for life through to a short term of imprisonment and a fine. Now, this is important because what it meant is that these trials were not zero-sum games organised just to determine innocence and guilt. They were also opportunities for the accused, if they saw fit, to demonstrate contrition and encourage judges to punish leniently. Now, mercy, as I argue in the chapter, played a significant, if hitherto unexplored, role in sedition trials from the very start. So the first trial for sedition in India results after the popular anger when the colonial state passes a new law that raises the age of consent in India to in 1891. And this follows the horrific rape and murder of the child bride from Rani Das in 1890. The Act doesn't outlaw child marriage, but it does make the consummation of any marriage before the age of 12 rape. Now, the amendment wins the praise of medical reformers and prominent women-led reform organisations, but these restrictions on male authority infuriate conservative groups who argue this openly contravenes the proclamation's promise to not interfere in religion and custom. Now, anger is especially strong in Bengal, and newspapers rail strongly against the law. Now, this controversy leads to a dramatic growth in the size of the vernacular print press, and much to the concern of the government, anti-bill newspaper circulation easily outstrips those supportive of the Act. So during a period of unrest, the Bengal government asked its legal advisors for the first time to consider the possibility of prosecution under this section 124A. A Calcutta-based newspaper, the Mangalashi, the most widely circulated anti-reform newspaper at the time, is chosen as a suitable target, and the idea is the prosecution would send a firm message to newspapers of other editors of other newspapers, bringing the print press back into line. Now, the paper's editor, owner, and 2 other employees were arrested and charged with sedition and defamation. The trial is held in the High Court of Calcutta and is presided over by Justice Kumar Pethuram. He is joined by a special jury. This is important because eligibility into special juries was much higher. It required a high proficiency in English, which produced smaller pools dominated by Europeans. So in this instance, we have a jury composed of 7 Europeans, 1 Bengali, and 1 Armenian. Now, during the trial, the defense and the prosecution engage in a robust argument about this definition of disaffection, the term colonial officials had been so concerned about. The defense tried to narrow the meaning of the crime to align it strictly with the nature of sedition in England, arguing that there should be no difference between metropole and colony. The prosecution, by contrast, suggested the offence had to be constructed and understood differently than it was in English law. It had to be broader, essentially. Now, Pethuram sums up to the jury, and in doing so seeks to clarify this issue. He hands the jurors a copy of the offence and notes the following. It is sufficient for the purposes of the section that the words used are calculated to excite feelings of ill will against the government and to hold it up to the hatred and contempt of the people. So he basically says this needs to be understood very, very broadly. Now, for all of Pethuram's attempts to cast sedition's net widely, the jury does not come to a consensus. 7 jurors voted to convict and 2 to acquit. Now, in a move that would cause consternation from within the colonial government, Pethuram states that he would only accept a unanimous verdict. The case is postponed until the next session, at which time a new jury will be impaneled. Now, the prosecution has basically hit a stumbling block. It's at that point that the editors submit an apology to the government through a written petition. The state accepts the apology and halts the prosecution. So early studies of this trial have underscored the importance of Pethuram's capacious definition of disaffection as a key moment in the criminalisation of political criticism under colonial rule. And it is certainly true that the government were very happy with this outcome. They believed it would hold them in good stead in future trials, and it would act as a deterrent for other newspaper editors. However, the role played by the petition from the accused was an equally important aspect of this episode. It was the editor's act of submitting an apology which allowed the introduction of the discourse of mercy into this process. It enabled the state to drop charges without fear of embarrassment. And so to understand how this worked, it's really important to take note of the tone and content of this petition, in part because this would become a model that future editors and publishers would use when they were in court. So what was in this petition? The petitioners, sorry, it's a little small here, but the petitions begin by promising the government that the editors had not intended to excite disaffection, but they do accept that the articles were, quote, intemperate, disrespectful, and unjustifiable. They explain that they now recognize their mistake and express, quote, heartfelt sorrow, and offer to apologize publicly if necessary. They profess their loyalty to the British government and express their faith in the benefits of colonial rule. They presented themselves, I suggest, as apologetic, accidental, and downtrodden seditionists. The petition then ends with a prayer for clemency, stating that they unreservedly throw themselves on the mercy of your honour. The petition is then published in full in the Times of India under the header, The Apology. Now here, echoes of that amnesty in 1858, I suggest, can be found. The decision to stop the prosecution did not simply ask that the subject plead guilty. It also required the accused publicly relinquish their political agency, explaining a political crime through the frame of ignorance and accident, and ask for mercy. So what happens next? Over the following years, many more editors and publishers are placed in trial for sedition, but judges no longer ask for unanimous verdicts, and so these editors are generally prosecuted. However, the possibility of leniency and reduced sentences, because of this wide discretion in the section of the code, creates the opportunity for future editors to follow this performance, and in the process transform sedition trials into choreographed courtroom performances that were repeated again and again. So these generally went something like this. The accused pleads guilty, apologizes to the court, and offers to print an apology. The judge then sums up the case, after which the jury finds the accused guilty, but recommends some form of mercy. Now, after this, the judge asks the accused the same question each time. Have you anything to say why judgment should not be passed upon you according to law? Now, this was a really crucial moment. It was the final opportunity of the accused to demonstrate their willingness to participate in this spectacle, to personally acknowledge the state's claim to sovereignty, and in most cases, pray one more time for mercy. When that was done, in most cases, the judge then exercised their discretion and sentenced the accused to a relatively short term of imprisonment. Now, in the book, I argue that these trials were important and highly theatrical negotiations between the state and its dissenters. In crowded courtrooms, educated men, generally heralding from elite backgrounds, stood in front of colonial judges, professed their loyalty to the British Empire, and pled for mercy. In exchange for lenient sentences, the good colonial seditionist was expected to express their contrition and publicly relinquish their politics. Now, a lot was clearly demanded of the accused here, but I think these spectacles also show us a degree of colonial vulnerability. The successful reassertion of state power was resting precariously on the law's ability to compel critics of empire, whether through fear of punishment or the possibility of leniency, to play their part in this theatre, to place themselves at the mercy of the colonial judge. Now, as you know, problems would arise when subjects no longer saw fit to play this game. So it's with that I want to turn to Tilak, who departs in important ways from these other editors and becomes the first nationalist figure to fully uncover the problematic political work of mercy in colonial India. Now, as a brief reminder, by the 1890s, when this wave of sedition trials was underway, Tilak had already become one of the most significant nationalist voices in the colony, in part because of his role as a prominent newspaper editor, which his newspapers enjoyed very large circulations in Western India. Tilak was also somewhat of a serial seditionist. He's charged with this crime 3 times in his life. In the chapter that you have read, I look at the first 2 of those trials. And for the purpose of today's talk, I want to place special stress on 2 things Tilak does. First, in neither of his trials does he accept the possibility of his guilt. And second, because he refuses the possibility of his guilt, he's able to continue to pursue justice long after the trial ends. He does in the process, I argue, he performs a politics of what I call radical innocence. Now, in the first trial in 1827, Tilak's defense focuses predominantly on 2 arguments. The first is that there are no jurors fluent in Marathi, which is the language in which the articles had been written, and so the court is not competent to understand the meaning of the writings that had been deemed seditious. And second, that the law of England protects the freedom of the press to criticise the government, and that these same protections should therefore apply in the colony. These arguments fail, and the jury finds him guilty. At the end of the trial, when the judge asks Tilak that question, he responds not by repenting, but repeating his criticism of the composition of the jury and stressing his innocence. He is sentenced to 18 months in prison. Now, within a decade, Tilak is back in court for sedition again, at which time he now defends himself. As you can see from the photo, he speaks directly to the jury rather than the judge. And he again, though, fails to convince the court of his innocence, but he responds to the guilty verdict this time with an even more assertive embrace of his innocence. He says, as you can see, all I wish to say is that in spite of the verdict of the jury, I maintain that I am innocent. There are higher powers that rule the destiny of things, and it may be the will of Providence that the cause which I represent may prosper more by my suffering than by my remaining free. As Tilak becomes more unrepentant, the court responds by punishing him with a more severe sentence, offering further evidence of the relational character of mercy and terror. Now, what makes Tilak's innocence radical, I argue, was his refusal to deliver the court an apologetic and accidental seditionist praying for mercy. In doing so, he refuses the court closure. Now, this is really important because existing studies of these trials have restricted themselves to the courtroom itself. However, because he rejects the court, he rejects the court's verdict and he describes it as a failure of justice, he sets the terms to continue his fight long after the trial ends, and it's that journey that will end him making a key discovery about the function of imperial mercy. Now, Tilak's post-trials are very interesting in both cases, but I'm going to focus primarily on what he does after 1908 during this talk. Now, the High Court in India was, in most cases, the final court of appeal for criminal offences in India. However, there were options available to Tilak after his conviction. The first was the Privy Council. Located in London, the Privy Council was the final court of appeal across the empire, but it very rarely hears criminal appeals. Now, there are two paths to the Privy Council. The first was to approach the High Court to grant permission to petition to appeal. Tilak does that immediately. He submits a petition, points to various errors during the trial, and asserts that he had not received justice. The High Court disagrees and rejects the petition. Second, all subjects of empire enjoyed the right, when resources permitted, to approach the Privy Council directly with an application. Tilak submits such an application. After 6 months, it fails to interest the judges, who dismiss it. Now, at that point, one of Tilak's associates writes to him to say that, quote, all avenues to justice through courts are now forever barred. However, Tilak believes that a final appeal might be possible through a petition to the House of Lords. Now, this was a long shot. In its judicial function, the House of Lords had a jurisdiction to receive appeals, but that did not extend beyond England, Ireland, and Scotland. Tilak knows this and understands that he has very little chance of success, but he still drafts a petition which fails. Now, as these petitions on the basis of injustice are floundering, it's suggested to Tilak that an early release might be possible through a petition of mercy. Now, this, however, would be contingent on him accepting strict conditions. Either he would need to fully withdraw from politics or minimally stay quiet on select issues. Now, it's this that provokes Tilak's most extensive comment on mercy. He writes that he would only accept mercy on 3 specific grounds: 1 legal, 2 equitable, and 3 humanitarian. And then he says if these all fail, we should not go beyond them. Now, the legal option related to the Privy Council, which he says has now failed. Equity related to civil rights. So Tilak argues that every subject of empire has the right to a trial by jury, and in the colony, the use of special jurors essentially sort of denied Indians that right. And humanitarian grounds referred to the severity of the sentence. So Tilak says that he would accept mercy if the state accepts that the sentence was too severe because of his age, his health, or his public position. Tilak then goes on to explain at length why he can't accept mercy on other grounds. He explains that to do so would be to undo his life's work, and that to win freedom by abandoning his right to participate in political life would be, in his words, to live as a dead man. Now, I think this is a very important comment. For the first time, Tilak's radical innocence was dragging the political implications of mercy into the open. connecting the curtailment of political rights to colonial subjects and the lack of full political life afforded to Indian people to the availability of colonial mercy. Now, with these lines drawn, Tilak submits a series of petitions for pardon on the strict grounds of injustice, but with no indication that he will accept any conditions. Petition after petition fails, and in August of 1913, just months of his time to go, Tilak writes that there is, quote, not even the slightest chance of my early release. Nonetheless, he continues to urge his friends to press his case, writing that, quote, we must not give up trying again and again to the last moment. Knock and it will open, says the Bible. Now, what is Tilak trying to achieve here? On a purely practical level, he was sustaining pressure on the government and maintaining public interest in his plight. I also think, though, there was clearly a deeper politics at play. Tilak had transformed petitions and appeals into political technologies that enabled him to constantly repeat his argument about colonial injustice, test the outer limits of political rights available in the colony, and exhaust popular faith in the possibility of receiving justice from within imperial institutions. As he refused to moderate his position on mercy, Tilak asked a specific question to the High Court, the Privy Council, the House of Lords, and ultimately the King himself. When colonial courts were understood as sites of illegal and despotic terror, could a colonial subject expect a merciful sovereign to intervene on the simple grounds of justice? As his efforts were rejected, withheld, and dismissed, he seemed to have found his answer. Now, as I argue in the chapter, Tilak's thinking about mercy represented a key moment in anti-colonial politics. By being left in prison for the full 6 years, Tilak's experience exposed how the relational work of terror and mercy operated, compelling Indians out of fear to participate in the colonial system, relinquishing their agency in colonial courts in exchange for liberty and reduced sentences. Now, Tilak's interventions were really important, but it would take another political leader to turn the recognition of mercy as a political problem into an anti-colonial praxis, one which transformed the decision to reject mercy into a formidable act of resistance. And so what happens after the chapter, just to give you some sense of where the book ends, is Gandhi, which I'm going to give you a brief overview of today. So Gandhi builds on Tilak's trials in really interesting ways. Gandhi's thinking about mercy begins to develop a few years after this trial in the aftermath of the Amritsar massacre, perhaps the most infamous period of colonial violence during colonial rule. Now, what follows the massacre is a period of legalized terror. Martial law is declared in 5 areas of Punjab and would remain in force for almost 2 months. Now, during this period, colonial records found that 2,537 people are tried in martial law courts, with 1,804 convicted, many punished with extremely severe sentences. So I've got a table on the screen which kind of shows you that. Now, the harshness of this period draws sustained criticism from nationalist organizations and the Indian press. And so in an attempt to protect the image of colonial justice, the local government starts to reduce these sentences through an organized program of mercy and commutation. So in February of 1920, only 88 of the original prisoners remain in jail. Now, Chelmsford, the viceroy, explains this program of mercy, and in doing so returns us to a logic that should be familiar to us by now. He says the following: "It is my desire now, and it is that of His Honour the Lieutenant Governor of the Punjab, to exercise clemency towards the unfortunate, misguided men who were led away by, quote, some educated and clever man or men, to use Mr. Gandhi's words, to commit outrages. For some time past, Sir Edward McLaughlin has been busily engaged in reviewing the sentences passed, and in every case possible, he has tempered justice with mercy." Now, what we are seeing here again is that mercy will be available to a public on the basis they agreed to have been misled by a small group of guilty ringleaders. Now, the decision to directly invoke Gandhi's name here was certainly a provocative one. Gandhi had earlier criticized the use of violence by some protesters, but he certainly was being taken out of context. Gandhi responds directly to this speech, stating that the public had in fact never asked for mercy. The demand was for simple justice. It was during this period that you see the problem of mercy becoming gradually clearer in Gandhi's thinking. In a warning to the public, Gandhi, for instance, explains that reductions in these sentences were akin to blinds, and they shouldn't be allowed to, quote, lull the public to sleep. As he continues to comment on cases in which commutation was offered, Gandhi's position hardens further. On occasions, he openly courts the state's terror, arguing in one instance that if the accused were truly guilty of such a serious offence, they should be hanged. The following year, Gandhi launches the non-cooperation movement, which lasts from September 1920 to the early months of 1922, and this is where my book ends. Now, this is generally acknowledged to be the most serious encounter between colonial state and anti-colonial nation since 1857. And it begins with Gandhi's famous promise that they would attain Swaraj or self-rule within a year through an organized program of resignations, boycotts, and ultimately a refusal to pay taxes. Now, it's really important here to pay attention to how Gandhi himself describes this movement. Once mercy had been fully rejected, he consistently describes this non-cooperation through the language of war. Although underscoring that this war will be fought without armed struggle, he argues that in all other aspects it would be no different. He compares the satyagrahi to soldiers, the participation in this movement as akin to national conscription, one that would require the individual to make the ultimate sacrifice, to die for the cause. During this period, Gandhi himself writes on multiple occasions about his own wish to be killed by the colonial states. You can see one such example on the screen, but there are many others like this. Now, non-cooperation does not bring about self-rule within a year, and the movement begins to fall apart in 1922. Gandhi is arrested and charged with sedition, like Tilak. Now, his courtroom performance is a wonderful read, and I suggest everyone, if they have time, looks at it. But I just want to note a few things he does here, which are different to Tilak. First, after the trial, the charges were read to Gandhi, he presents himself in court not as a political leader, but as a farmer and a weaver. He then pleads guilty. In pin drop silence, he offers the following statement. I've just taken a little bit of it to the court. I do not ask for mercy. I do not ask for any extenuating act of clemency. I am here to invite and submit to the highest penalty that can be inflicted upon me for what is in law is a deliberate crime and what appears to me to be the highest duty of a citizen. Now, in the book, I argue this statement is a full inversion of the work intended by the amnesty of the Queen's Proclamation of 1858. In that earlier founding moment, the colonial states had attempted to undermine a popular political uprising through the strategic provision of mercy for some and terror for others. As every rebel later submitted to the Queen's mercy and surrendered political agency, the legitimacy of imperial sovereignty had grown stronger, and the memory of war, Mughal sovereignty in Hindustan had slowly faded. By contrast, Gandhi here embraces full responsibility for his actions and demands that the state punish as severely as possible. Courting the state's terror, he did so in the guise of an ordinary citizen and demanded every Indian similarly reject British mercy, refusing the colonial strategy of funneling political agency into the hands of ringleaders and agitators. In refusing to accept mercy, Gandhi's necro-political gambit was a demand to be killed as a citizen and a soldier rather than as a subject and a criminal rebel. It was an attempt to recover the sovereign right of the Indian people to wage war. I suggest here that this moment Gandhi moves beyond earlier anti-colonial critiques to achieve something that would ultimately be irrecoverable for the colonial state. In the subsequent 2 decades, the colonial authorities would be forced into a series of retreats in response to a nationalist movement that no longer spoke the language of British subjecthood or relied on petitioning British institutions for incremental reforms. They had begun the process of dismantling empire on the path towards post-colonial freedom. So to briefly wrap up, my book as a whole hopefully demonstrates that to study mercy alongside terror presents distinct possibilities for histories of law, sovereignty, anti-colonial politics, and colonial violence. For one, in the chapters that I haven't been able to discuss at length today, I argue that when we study violence alone, we fail to capture the unevenness of state terror and the important political and legal processes that led different subjects to become more or less vulnerable to punishment underneath an extraordinarily bloody colonial order. And secondly, and as I hope this talk has demonstrated, we also risk marginalizing the important breakthroughs made by anti-colonial thinkers who challenged, tested, and ultimately rejected the authority and legitimacy of the colonial state. Finally, and at the risk of a very drastic gear change, it's also worth noting that in recent years, popular interest in the history of imperial mercy has become an increasingly controversial terrain of contestation within contemporary politics in India. Scholarly intervention in this debate, however, has been largely restricted to what one might say rather questionable historical takes on India's nationalist past. My book hopefully offers a much more grounded and critical account of the important place that mercy played as both a tool of empire and a crucial site of anti-colonial resistance. So with that, I will leave it there and look forward to any questions or thoughts you might have about either this chapter or the wider book project. Thank you very much.